DTMB is the purchasing authority, but an end user agency is the primary user of that contract. So again, these healthcare RFPs, DTMB is the purchaser, but it's really our Department of Health and Human Services that is the end user agency. So we'll represent that end user agency in those contract negotiations. But if a question comes up related to federal regulations in that space, what we'll often do is we'll refer them again to their primary legal counsel who is more familiar with those legal and federal requirements. And so we represent them with respect to the procurement, but not necessarily with the regulatory requirements because we simply don't have the expertise in that area. So the last slide that I'll talk to you about for this particular area, I guess the second to last slide, is how we deal with vendors. So I think we've already talked about the fact that generally we consider contractors to be our clients, except in the very obvious situations where, for example, we're in a dispute with that particular vendor. At that point, they are not involved in attorney-client communications. They are essentially an opposing party. So we don't involve them in those discussions. In any negotiations, either for new contracts with a particular vendor or with an incumbent vendor, I should say, or for any new contracts, we don't consider them our client. And the other thing to keep in mind is that especially if we're negotiating contracts, we want to make sure if we know that that particular vendor is represented, that they bring their attorneys with them to meetings where we are present. So we try very hard to follow, it's either the ABA Model Rule 4.2, the Michigan Rules of Professional Responsibility have adopted the ABA Model Rules, so it's our 4.2 as well. And so even though it's not necessarily an adversarial party, like we're not in litigation with them, we still want to make sure to give them the opportunity to have legal counsel available, to take a look at the contract, make any red lines if they feel they have to make red lines, and to represent them in any negotiations. Not all vendors will want to engage their attorney, especially if they have to hire a law firm, they don't want to go through the expense. That's fine. We ask them to put that in writing, though, to indicate that they don't want to engage their attorney at that point. Or if they do have counsel and the counsel really doesn't want to be there, we'll ask their counsel to put something in an email saying it's okay to talk to our client.
Well, also, if I've had it happen where the vendor said, well, we have counsel, but they're not engaged on this project. What does that really mean? I mean, if it's outside counsel, that's one thing, but if they have an inside counsel, in-house counsel, to me, they're represented, and I don't want to, have any discussions with them unless I have a waiver in writing by their in-house counsel or they're on the phone with us. So just, be aware of that too.
Jessica?
Just a quick comment here. The thing that I've seen more often than I'd like to say is when our procurement officers tell us that they've been in a meeting with a supplier and the supplier's counsel, and the supplier's counsel seem to have no problem with that. So making sure that your procurement officers know in advance that if somebody else's counsel shows up, they need to stop the meeting and talk to you, I think is vitally important.
That's an excellent point. Sometimes we do find that on occasion, the client has been a lot better about that. So every time we do client training, we do go and we do client training routinely. We talk to them about legal terms, basic contract formation, things like that. We do mention that if a supplier's counsel is present, sometimes the supplier doesn't even tell them that their counsel will be present. They should stop the meeting and wait for an assistant AG to be present and engage so we can be there to represent them. So that's an excellent point. And then this last slide that I'm going to talk about is about potential waivers. So this is really important with respect to reply all to emails or meeting invites. There have been occasions where I get meeting invites that have 20 or more invitees, and I actually have to go through the meeting invite list to see if either all of those employees are state employees or if there's going to be a vendor present. The clients, we've repeatedly advised them to please let us know if a vendor is going to be present on a call, because we have to be, of course, very careful about what we say on that call. And generally, like, I've asked clients to cancel calls before if I think I need to talk to the client first before talking to the vendor. McCall?
So in the day and age of, I'm sorry, it feels weird because I'm talking this direction and I know you're there.
It's okay.
In the day and age where more and more folks are walking and talking and looking like employees, but are likely contractors, for example, think about your IT shops and such. How do y'all verify, who's really an attorney, really an employee, because their email addresses even reflect state email addresses sometimes, at least in our state.
Right. So for us, if they've been brought into the state fold, we went through the process of working with our IT services to make sure that if they're giving a Michigan.gov email address to a contractor, that it has that dash contractor designation to it, so we can see that they're a contractor. The trickier part, and we've had this come up a lot more frequently than I would like, are the ones that are not actually, that are contractors but haven't been brought into the state fold. So I always ask, who is this person? Why are they there? Like, what is the purpose of them being on the call? If there is no purpose of them being on the call, I will explicitly tell the client, listen, I can't guarantee that this conversation is going to be covered by attorney-client privilege, and make sure they understand the ramifications of doing that. Because privilege belongs to the client, it doesn't belong to us. So if they're okay with potentially waiving privilege, then that's fine. But they also need to understand that if you waive it for a particular conversation, if you waive it for an email string, which is another place where there can be a potential waiver, be very careful about hitting reply all to any email, especially if there have been non-state employees, non-contractors, or contractors that haven't been brought into the state fold on that recipient list. And the ABA even warned about hitting reply all and responding to emails without knowing who the recipient is, because once it's waived, it's waived. You can't put the genie back in the bottle. So the client agency really needs to understand the potential ramification for doing that if it's an especially sensitive topic. So I have a specific email signature that includes, this is covered by attorney-client privilege. It may constitute attorney work product. It's all screamy and in bold letters and things. And then in addition to that, I will put in like 18-point font, bold, attorney-client privilege, do not forward to non-state employees. And then there's also the FOIA exemption. So once you waive attorney-client privilege or forward it outside of state government, you can no longer assert that particular FOIA exemption on the body of the document and on the legal advice in that email. So it's very tricky.
But
Yes.
One thing to prevent or discourage clients from just forwarding my advice wholesale is I'll advise them and then I'll put a little intro and say, here's something you can paste into a new email to the vendor, like summarizing what I just said, because there's this tendency to be like, see below for
Right.
like lawyers' concerns. I'm like, please don't do that.
Yeah.
I'll write like, dear sir, I'll actually write it for them, which I suppose is not that much extra work, but it'll encourage them to paste that into an email versus forwarding the string.
That's a really
Yeah.
great idea. The other thing is, if you're taking a look at vendor red lines, often what we'll do is we'll put in comments to the client saying, hey, this may not be a good idea, here's why. And then they'll forward that document with the comment to the vendor. Nothing I could do about it at that point. So again, it's just making sure the client is aware. Privilege does belong to them, but they need to understand. The other thing is that they need to understand, the random state employee, low level, can waive privilege for the director of their department and the governor. This is not something that you want to get in trouble for if you accidentally forward something. So that's important to make sure the clients keep in mind. I have a whole other thing about parents patriae and protecting attorney-client privilege in those circumstances, but I think I'm running over. So if there's time, I may jump into that because that is something that has come up for the state of Michigan, and I want to make sure other states are aware of it.
Yeah, and I think to follow up on that, another thing that we kind of look out for is to be proactive.
Is your mic working?
Is it? Can you guys hear me? Is this working?
Okay.
Okay. Sorry about that. Is to talk to the clients and educate them, right? Suzanne mentioned we do training sessions with our clients, and those training sessions are good opportunities to kind of convey some of this information to them so they become more sophisticated as time goes on. And we've actually seen results on that, so that's pretty impressive. So your role as a government attorney, in some ways it's the same as an attorney in the private sector, right? You have to assist your client achieving their goals within the bounds of the law, but as government attorneys we also have to keep in mind that we're usually sworn to protect the public's interest, including the public taxpayer dollars, or Suzanne calls it the public fisc.
Fisk.
Yep. And the
Fancy
public
pants term.
and the public's data. I guess it's kind of similar to how we're officers of the court, right? As well, we have a duty to the court as well as to our clients. So we have an additional duty to the taxpayers, not just the client. I guess the taxpayers in the end are the client. But your role as a government attorney may vary by state or by assignment, again, depending on where you are. But in all respects, again, your role as a government attorney is to help your client achieve their goals while ensuring compliance with the law and protecting, again, the public fisc and the public's information. So we're going to talk a little bit about a business decision and a legal decision. So what is a business decision? And there was some mention of this earlier today, because I think it's a topic that comes up a lot. If someone asked me 7, 8, 9 years ago, what is a business decision versus a legal decision, I don't know that I would have had a really good answer for that. And you kind of go through it and you kind of learn as you go along, and it can be fluid sometimes. But what is your client trying to buy? Is it clear? Can you help with that? Can you help clarify the language? Do you have a role with that? Because as that bottom bullet point, as we know from law school, you have to have a meeting of the minds to have a contract. And I have an example. So when my oldest daughter, who's now 12, was not yet 3, I was trying to get her to bed, and she wanted me to read more books to her, and I said, okay, fine, one more book. So she said she agreed. So we had a deal, right? I would read one more book, and she'd go to bed. That was our negotiated understanding. I read the book, I said, now go to bed, and she said, now read it again.
The same book.
The same book. I
Yeah.
said, well, I thought the contract was getting me what I wanted, right? Not so. So know what your client's objectives are and see if you have a role in helping clarify, what the language of the contract should be so that they actually are buying what they intend to buy. Software, IT contracts, right? We all do a lot of that. If a vendor proposes something as far as downtime, for example, for cloud services, that's 2 or 3 days, or that seems unreasonable to you, is that a business decision or a legal decision as to whether you can agree to that or your client can agree to that? Well, I don't know. Does your client have a statutory duty to provide the services, that are behind the software here? And are they violating that mandate if the system's down for 2 or 3 days? So just be aware of those things: the RPO, the RTO times, recovery point objectives, recovery time objectives, things like that. So in your role, you'll come across decisions that require your advice, and decisions that are yours to make, and decisions that are not yours to make. And recognizing the distinction can be important, or will be important. So what is a legal decision? So some things that most likely or clearly be a legal decision include, does your client have the authority to make this purchase? Our client does not have, for example, authority to make grants. So if they came to us and said, we want to give out this grant, well, you don't have authority to do that, so you can't do it. Is the subject matter of the contract legally permissible? If your Department of Military and Veterans Affairs wants to hire mercenaries to invade your neighboring state, that's probably illegal, so they probably can't do that, right? Do you have all legally required terms in the contract? Do you have the non-discrimination clause, the prevailing wages, things like that? Dealing with the IRS, they have certain requirements. You guys mentioned that earlier, the Pub 1075. Has anybody ever heard of that, Pub 1075? Exhibit 7?
We've had so much discussion about Pub 1075 with client agencies and IT contracts that we actually considered opening a bar called Pub 1075. And then we figured nobody but lawyers and tax professionals would understand what we were talking about, so it didn't really work.
Yeah.
But I was sad by that.
It's a good idea. Is the order of precedence correct, right? I know Keith talked about this earlier. It's really shouldn't be in your client's wheelhouse to make that decision, because you have to make sure the integrity of the document, the contract, is maintained, so that the vendor's paper doesn't accidentally slip in and basically supersede the entire agreement that you're negotiating, like a EULA, for example, or some other agreement. Is your client complying with the procurement rules and laws? There's been a lot of discussion about that, right? Is the bid responsive? Is that your client's decision or yours? I mean, did the bid come back with by a reseller? Are you now being asked to sign 2 contracts, one with the bidder and one with the software publisher, where you were only really intending to bid out for 1 contract, right? Is the entity who's signing the contract the bidder? Right, this comes up a lot, actually, where some sister company or an affiliate company, right, is actually going to end up signing the contract, but they never signed the bid. They're not the ones that submitted the bid. So those are kind of things, just to kind of be aware of and look out for, that maybe tend to lean towards what is a legal decision versus what's a business decision. And again, the distinction between the two is not always clear. Does the contract open up your state to potential civil or criminal liability? I think there was some discussion today about folks having personal responsibility or criminal responsibility for acting beyond their authority. I mean, so obviously be aware of those things. Are you, again, jeopardizing the public fisc? Does it jeopardize the public's data? Again, with the Pub 1075, if there's federal tax information as that's defined, you have to have Pub 1075 Exhibit 7 in the contract. You can't just reference it. It has to actually be attached to the contract. Whether or not to include that, that is a decision for you to make and to advise your client on.
One interesting thing it's not interesting, it's slightly terrifying, is if you don't have the necessary requisite federal language when you're dealing with these highly regulated data types, the feds could actually decide not to share data with you anymore. So I don't know if your revenue collection agency can collect revenue without getting federal tax information, but I imagine that's pretty hard. So that is another thing to keep in mind, and that's why Erik is saying, even though you think the client may want to say that it's a business decision, it's actually not.
So, your job, is to advise your client on the risk on certain things, and let's go to that second to last bullet point here. Is your client giving the vendor too much of an ability to terminate the contract or sue for breach, or are you limiting their responsibility in too much? With respect to, for example, the termination provision, if you give the vendor the right to terminate for non-payment or some contract dispute, again, are you putting at risk your client's ability to perform a statutorily mandated government function just because of a contract dispute, right? I mean, is that something that you can have your client agree to, or how would you advise them on that? So you have to be aware of what their obligations are as well in the context. So in the end, right, you're going to give them advice. We all know clients don't always listen to advice, but at least we're getting paid to tell people what we think. So.
Which I do all the time, by the way, in case you haven't noticed. I have lots of thoughts, and I feel free to share them.
Nobody listens to me anywhere, but at least at work I get paid for it, to talk. So, we have a few scenarios, and these are kind of basic, right, and just to kind of get some discussion going. So at your table, just kind of talk about this and figure out what you think. But this is a red line by a vendor. A bid went out for commodities, and this is what they came back with in the risk and loss of title section. Is this a legal decision or a business decision?
Bad idea is the correct answer, yes.
Bad idea, I would not do it. I'd laugh.
Sorry, I'm hearing
By the way,
conversations about leaving it on a doorstep.
we did a
and-
run-through of this, right? And
Yeah.
you guys sounded exactly like this when we were doing our run-through. All right, business decision, legal decision. All right, I think unless there's a statute that prohibits, risk and loss of title being transferred upon delivery, this is probably a business decision. Again, it may be a bad idea, right? But your role here is to understand the significance of this change and to be able to communicate that to your client, what the risk is, how it changes the risk profile of the contract, of the transaction at issue. And some clients will need a dissertation and an explanation. Other clients I've experienced just want to know the answer, yes or no, depending on what the buy is and how complicated it is. But this is a commodities contract. But the language as originally written, right, it would have protected your state in the event that something happened to the shipment of the commodity before you had a chance to go through any acceptance criteria. So in Michigan, maybe in a lot of your states, payment is usually triggered by final acceptance. So we have a chance to inspect and look at and accept or reject the goods. And if we accept them, that triggers payment. So we wouldn't be obligated to pay unless we accept it. This change would allow the contractor just to leave it anywhere at the doorstep, or and as soon as they deliver it, the risk of loss passes to the state. So this is probably a business decision unless there's some statute in your state that would prohibit this red line from being accepted.
It's okay, you don't have to move.
Oh.
So for this next scenario, a vendor wants to insert this language into your contract. Feel free to discuss at your table, do we think this is a business decision or a legal decision? Legal. So in Michigan, this would absolutely be a legal decision, and it would be a hard no. We do not have, that some other states have, which I admire you for having this in your state law. That is a statutory prohibition on indemnification. We don't have something that nice and explicit. We have attorney general opinions and we have case law indicating that the state of Michigan cannot indemnify third parties because that would be an unauthorized extension of credit. So unless there's a legislative appropriation to actually allow for indemnification, we do not allow indemnification. But in Michigan, yes, you are correct. This would absolutely be a legal decision. Maybe in some other states, if you don't have a prohibition, that's a business call, although we would certainly advise that is not a great idea.
Yeah, and there are constitutional provisions to back up
Right.
those AG opinions in Michigan. So, what is this? What is it? And then is it a business decision or legal decision if a vendor adds this to a contract as a red line?
Okay.
Legal, business?
Legal decision.
Yeah, it's indemnification,
Sorry, I
right?
jumped the gun.
Property damage.
Yep.
I mean,
Yeah, I mean, this is just another word of saying indemnification. The state's going to have to indemnify you if, because you're promising to pay attorney fees and other expenses for which there's not been an appropriation, right? So you may end up in a lawsuit and the court may order you to pay these things, but that's different, right? That's a judgment, but you haven't waived the ability to contest, whether or not you have to pay those. The contractor will have to make those arguments and win. So this is just indemnification by another name.
So the next scenario, a contractor removes this language from your template terms. This is actually language that would be in our template terms. Do you think that's a business decision or a legal decision, hybrid decision? What do you think?
legal decision.
Why do you think it's a legal decision?
Well, what I'm reading is
Should get
that
this
a
microphone.
no event, will you limit? Oh, thank you.
Yeah.
You put a limit under the terms of whatever your recovery is to a specified to the maximum amount of fees payable under the contract.
Yep. Sorry, go ahead.
So, yeah, it's limiting liability.
Right,
and your damages,
right.
and that's a no-no.
Well, so what is this? What is the contractor removal of this provision? What does it do to your This is your contract. This is your template language. And pretend like we didn't strike it through because it's too hard to read. But just pretend they struck it through. What does that do?
Well, it's
Go ahead.
Gives the state uncapped liability.
That's correct.
Right.
It uncaps the state's liability for all these different things, right? So, what would you do in this situation then? Your client's now faced with a request to have uncapped damages in this contract.
I mean, I think it's a legal question because at least in Delaware, you can't have unquantifiable liabilities like that. So it's kind of like a hard no.
Right, which is awesome for Delaware. Michigan doesn't necessarily have a prohibition on uncapped liability. We do have the same constitutional prohibitions on like extending the state's credit without a legislative appropriation. So we could make a similar argument to that. I see a hand up.
Which would affect your insurance coverage. So if the state has additional insurance, often the insurer bases their coverage on standard contract language. So what I'll often point out is this isn't even something that the agency has the right to agree to being stricken if it wasn't, if it wasn't mandated by statute, because it's really risk management has negotiated certain insurance provisions based on not having a limit on liability. Because guess who has to pay if
Right.
you need more? The state, if it's self-insured, the state has to pay, or the secondary carrier. So that's kind of how I attack it.
Okay.
That's an excellent point. We're a self-insured state, so that, again, not necessarily a flat-out legal no, but I think we would strongly recommend against it for the uncapped liability perspective. I don't think we could say you can't sign a contract with this removed, as that would be illegal. I don't think we could quite get to that point in Michigan, but every state, of course, is different. And we would, of course, say that that is an exceptionally bad idea to have uncapped liability. Coincidentally, we do not have a liability cap for contractors. So this is a one-sided liability cap in our templates. Sometimes contractors will try and get a liability cap in. We put exceptions and hoops, and then hoops for the exceptions and all sorts of things if we decide to agree to a mutual limitation of liability. And generally, we carve out indemnification and data loss. So,
And we also carve out the insurance coverage because we don't want our damages capped. The insurance coverage, to say, well, your damages are capped at this, so the contractor's liability is capped at the insurance amount, coverage amount. So we have, and I think that's actually something that came from Keith. But so if you go back to 4, I think that
Sure.
discussion on 4, it kind of illustrates the point that it's not always easy to determine whether it's a legal decision or a business decision, right? Something like how much are you going to pay them? Well, that's a business decision. But something like uncapped damages here, you may have a prohibition against it, you may not, right? So just be aware of those things. Choice of law and venue. Oh, so this is yours, right?
no, this is you.
Okay. So I think Keith talked about this morning as well, which I thought was interesting. So assuming that, you're a Michigan company and they want to make it Louisiana law, is anybody in here from Louisiana? And can you explain to me what even the Napoleonic Code is? Because I have no idea. So is this a legal decision or a business decision in your jurisdiction, or just what do you think?
I'm hearing some legal decisions. Yep. Okay.
So, who thinks it's legal? All right. How about business risk type?
Okay.
Yeah. So, there may not be a clear answer on this one, kind of like the previous slide, but unless your state has a statute that requires a provision to be in the contract that says, your home state law, form, all those things, then there may not be anything that's illegal about this, right? You might be waiving sovereign immunity, but Keith mentioned a case this morning, right, about you're not subject to, you have immunity in another state's courts, but that doesn't exclude federal court, right? So, again, it's not always a clear answer as to whether it's a business decision or a legal decision. But what happens if a contractor just deletes this in its entirety? This governing law provision just strikes it. Then what?
Complications, right? Yeah, so actually, we found ourselves in situations, which I hope will never be repeated in any of our lifetimes during COVID, where, we had vendors, we needed very quick turnarounds on purchases, and they simply wouldn't negotiate. Like they insisted on being subject to the laws of their state. The client, of course, and we didn't really want to agree to that. So because we don't have the statutory prohibition on agreeing to another state's law, what we did is we just took it out. And then we figured the majority of the performance is going to be taking place in Michigan. The payment's going to be taking place in Michigan. There's a contract, and our Court of Claims Act said all ex contractu, ex delicto claims against the state of Michigan must be brought in a certain court in Michigan. And so we're just going to go with that and hope, first of all, we hope COVID is over soon. And second, we hope the contract is over and done with and we won't run into any situations. But this did come up more often than I would like during COVID, but we got to do what we got to do. We have 10 minutes. Thank you. Thanks, Megan.
Is that a Penoy versus Neff reference about personal jurisdiction?
I think so.
Yeah. All right, go ahead.
So the next one, a contractor wants to add this to your contract terms. Legal, business. You think it's legal? Okay. So I agree. To a certain extent, this is legal. So I'll say in Michigan, we would never, with very few limited exceptions, which I don't even know if they still exist or if they changed the federal law on this, pricing is not confidential. So I think like Medicaid drug purchases, maybe there may be some confidentiality issues, but I don't even know if that still exists. Pricing is by case law not confidential. And actually, we post all of our contracts with the very limited exceptions of things where, like, the state police buys certain technology that they don't want the entire world to know that they're buying. So we don't necessarily post those contracts. That's an exception to the rule. Although the contract is available if somebody wants it and it won't harm state security. The terms of the contract absolutely would not be kept confidential. The names of contractors' employees, unless there's a really good reason, like they're being stalked by somebody or, they're a victim of a crime. But that would have to be separate and apart from the fact that they are just a contractor employee, right? Because all state employees are public record. So even our salary information, I don't know if that works in your state, but that's what we have. Contractor trade secrets. So this can get tricky. Sometimes a contractor will label their pricing trade secret. I've actually had contractors that labeled all of the red lines they wanted to make to our legal terms as trade secret. I'm like, what the hell is this? So yeah, the contractors can get really creative. Generally, I say things like, what the hell is this? Like, that's not gonna happen. And then I ask them if they wanna reconsider their stance. If they don't, I'll be like, okay, well, I don't know how this is responsive. So, and I talk to the client about that. But yeah, I think to a large part, this would be legal. And then there are some other things that maybe the client can agree to, like that trade secret piece. But you have to be, again, very careful about what the contractor is going to deem trade secret.
I had one recently where they wanted the names of the contractors' employees to be confidential. Well, some of the employees were listed in the contract as
Right.
the contact people for the contract.
Now, I will say, and I'm trying to move away from this, sometimes we'll actually have resumes as part of the completed contract that includes contact information like address and like cell phone number. I'm like, maybe you shouldn't put that in the final contract because it's out there for the world to see. If it's a business address and a business phone number, that's fine. But if it's a personal phone number, I don't know why they would put that on the resume, but I certainly wouldn't recommend keeping that in the contract if you can avoid it.
Yeah, and some your clients might have certain reporting duties to report some of the information that the contractor wants to be confidential to certain regulatory authorities or elsewhere. and a provision like that might impede that. So it would be another legal, I think, hurdle. So here is just the business versus legal decision we talked about. It's not always clear as to which it is. It depends on, the facts and circumstances in large part. Sometimes it's a little more clear. But even courts have to make this determination at times. And we know this isn't a substantive law class, but we just kind of pulled together some cases just to show you that courts go through this discussion as well. This was an employment discrimination case, and this is what the court said, in determining whether this hiring or firing or non-hiring decision was illegal or if it was a business decision. So it's a different context, and it's just kind of to show you that, look, courts deal with it as well. So I just thought it was interesting that they have to go through these things as well. I mean, I used to have, in the private practice, people come in and say, hey, I'm being discriminated against at work, and it turned out that their boss was just a jerk, which is not illegal. So, go.
So I apologize for the teeny tiny print on the slide. I will say that this is a really great case. If you're looking for more of an explanation and a dichotomy between a business decision, a legal decision, it talks about attorney-client privilege, it talks about work product. So I highly recommend this case. I'm not sure if you can read the site from where you are. It's 578 F 3rd 432. It's a Sixth Circuit case. It actually originated out of an Ohio district court case, federal district court case. And so what happened in this case, so Professionals Direct is an insurance company. It offers professional liability insurance, malpractice insurance. There was a law firm, I don't know if they're still around after this case, I have to say, but there was a law firm that did not do the most fabulous job in defending their client. Their client got an $8 million judgment against them. The client turned around and sued the law firm for malpractice. The law firm knew that this claim was pending, and it was actually pending appeal at the Court of Appeals, and they didn't disclose it to the insurance company. The insurance company, Professionals Direct, before they knew about this litigation and they knew they were getting sued, they were of the determination that we think we're probably going to deny this claim because they didn't disclose it. But they didn't tell the law firm that. They strung them along and said, we're going to reserve the decision on whether to actually do the coverage. And so the liability insurance company eventually denied the claim. The law firm got hit for a $10 million claim because all of the efforts to mediate it and to lower the judgment amount failed, so they got hit for a $10 million claim. They sued Professional Direct for it, and they demanded all the information related to coverage decisions. So in this particular court case, they had retained an outside law firm before suit was even filed, and the outside law firm worked with them on work with the insurance company on determining whether they had grounds to deny the claim. They denied the claim, and what the court said here is that now this was an outside law firm, but they assisted in the business decision because this is an insurance company and they are involved in the business of insurance. The business of insurance is deciding whether to pay a claim or deny a claim. Because that law firm was involved in making that decision, that was a business decision. It wasn't a legal decision. So work product, they couldn't assert the work product privilege, number one, because litigation hadn't been filed at the time, and number two, it wasn't legal. It was a business decision. There's also a really cool thing in Ohio common law that was adopted into statute that indicated that if there was evidence of a bad faith denial of an insurance claim, all of that information that would normally be subject to attorney-client privilege would actually have to be turned over for in-camera review. So the court actually said, privilege doesn't apply here because we think this was a bad faith denial because, again, they had always thought they were going to deny it. They just didn't deny it until later. So this is really a fabulous case. If you want to learn more about these things, I realize it's the Sixth Circuit, but you can shepherdize it and see if there's something in your circuit or something that may be helpful. So I hope we've given you things to think about here. I don't really want to scare you, but there's a lot of things going on in government practice related to attorney-client privilege, work product, FOIA, things like that. So keep those things in mind. One quick thing about parents patriae, I see Megan walking up, but I'm going to say this before she gets up here. So if your AG has the authority to bring actions in the name of the people of your state, which is a parents patriae claim, keep in mind that if your attorney general is bringing that case, even if your attorney general is general counsel for all of the state agencies, they are not necessarily clients when she's bringing that case, right? The client is actually the people of the state of Michigan in that case. So there may be an issue, and what you may want to consider is a common interest agreement. If your agencies want to share information related to the success of that parents patriae action, make sure to consider a common interest agreement if you think you need it to protect the attorney-client privilege of that information. So one little quick shout out there. We don't have a slide on it, but.
Yeah, and just one more thing real quick. Last year was my first year at NASPO at the law, and at the Law Institute, and here I am presenting. Get involved. It's worth your while. So.
Go ahead, McCall.
Oh, sorry.
Just one quick, you've been differentiating between business decisions and legal decisions. Coming from the Central Procurement Office side, we're often involved in order to be effective, we need to weigh in on the business decisions as we're helping them analyze risk, and being a partner in the discussion. It's not that we wave off and say, sorry, that's a business decision, we'll see you.
Right.
Right.
So being an effective partner for our procurement folks.
Yeah, I mean, sometimes you're going to have to let your clients and educate them on, well, this is actually your decision, but here's what these language changes mean, or here's what these proposals mean, or here's the risk, right? So that would be your role. You can't make the ultimate decision necessarily, but your role is, to advise and help them understand that it's their decision and, maybe guide them. So, yeah, thanks.
Thank you, everybody.